No one expected a 28-year-old press secretary to walk into the Supreme Court and leave the justices speechless. But when Caroline Leavitt stood before the most powerful legal minds in America, armed with nothing but a leather portfolio and her voice, history took a turn. What was supposed to be a public reprimand quickly spiraled into a legal showdown that would redefine the boundaries of free speech, institutional authority, and courage. As gasps echoed through the chamber and Chief Justice Roberts leaned in, one question remained: would she retreat or rewrite the rules? The moment Caroline Leavitt stepped into the Supreme Court chamber, the air itself seemed to tighten. At just 28 years old, she wasn't supposed to be the center of the most important constitutional showdown of the decade. But here she was. The young White House press secretary stood alone, clutching a simple leather portfolio, facing 9 of the most powerful legal minds in the nation. Her future, and perhaps something even bigger, the very boundaries of free speech in America, hung in the balance. Justice Amy Coney Barrett's gavel slammed down, silencing the whispers that rippled through the packed gallery. Reporters gripped their phones with white-knuckled intensity. Law clerks leaned forward in their chairs. Even seasoned justices shifted slightly, sensing that what was about to unfold would not be a typical reprimand. Miss Leavitt, Barrett's voice echoed, firm and clipped. This court finds your recent public statements concerning Fairfield v. Department of Education to be deeply troubling. You have 7 days to retract and apologize, or face criminal contempt proceedings. Most would have crumbled under that glare. Most would have bowed their head, read a prepared apology, and slipped quietly out of history's spotlight. But Caroline Leavitt had spent the last 3 sleepless nights studying old, forgotten rulings, piecing together a daring legal defense that no one, not even her own advisors, believed could succeed. She didn't flinch. Instead, she opened her portfolio, revealing a neatly prepared 15-page document. "Justice Barrett," she said calmly, "with your permission, I'd like to present my legal analysis before this court." The room froze. Even Barrett blinked. Leavitt's heart thundered against her ribs, but her voice never quivered. She had practiced this 1,000 times in her mind. She knew she wasn't just fighting for her career. She was standing for every voice that dared to question authority without fear of punishment. In Bridges v. California, she began, this court ruled that criticism of judicial decisions, no matter how harsh, is protected under the First Amendment, unless it presents a clear and present danger to the administration of justice. My statements did no such thing. A murmur rippled through the gallery. Some reporters put down their phones altogether, realizing that this was not the apology spectacle they had come for. This was something else, something rare. Caroline continued, citing landmark cases with surgical precision. New York Times v. Sullivan, Craig v. Harneywood v. Georgia. She didn't argue emotionally. She argued constitutionally, methodically building a shield of precedent around her words. Chief Justice Roberts leaned forward. Justice Kagan's brow furrowed in concentration. Justice Thomas, famously silent, shifted in his chair. Caroline's analysis wasn't just competent, it was brilliant. And it was working. But the stakes were enormous. If she overstepped, if she appeared too defiant, she could still be crushed under the institution's weight. Every word had to be perfect. Every citation flawless. She wasn't just speaking for herself. She was crafting a defense for future generations who might one day find themselves standing exactly where she stood, alone, yet determined. When she finished her opening argument, she gently placed her document on the podium and looked directly into the eyes of the justices. "I stand by my respect for this court," she said softly. "But I also stand by the First Amendment." The silence that followed was not empty. It was charged thick with the realization that something extraordinary was happening. A press secretary had just challenged the Supreme Court, not with bravado, but with reason, with history, with the very Constitution the justices were sworn to uphold. Caroline Leavitt was no longer just a spokeswoman. In that moment, she had become something far rarer. A citizen standing unflinching before the highest powers of the land, demanding not favors, but the preservation of the ideals that had built the nation itself. And the court was listening. As Caroline Leavitt turned to page 2 of her document, the silence in the courtroom had evolved from tense anticipation to stunned engagement. Her voice remained calm, but each sentence carried the weight of precise legal reasoning. No theatrics. No pandering. Just law, presented with the clarity of someone who understood the gravity of every word. "I would next direct the court's attention," she said, "to the decision in New York Times v. Sullivan, where this body held that debate on public issues should be uninhibited, robust, and wide open. Justice Elena Kagan adjusted her glasses. Chief Justice John Roberts leaned slightly forward, fingers steepled. From the press section, the rapid tapping of keyboards had stopped. Everyone was listening. Justice Barrett, Caroline continued, my statement did not accuse the court of corruption or bad faith. It criticized the legal foundation of a majority opinion, exactly the type of robust public discourse protected under Sullivan. If the First Amendment cannot shelter such words spoken by a press secretary, how fragile must it be? She paused. The chamber remained still. Justice Samuel Alito finally broke the silence. Miss Leavitt, are you suggesting that White House officials have carte blanche to attack the credibility of this court? Caroline looked directly at him. No, Your Honor. I'm suggesting that when those officials speak about the Constitution and law, they do so not with impunity, but with the same protections afforded to every American, especially when those words reflect legal disagreement rather than personal defamation. She flipped to page 4. Craig v. Harney held that judges are supposed to be men of fortitude. That case protected a newspaper editorial which called a judge's decision an outrageous miscarriage of justice. My statement, by contrast, was more measured, more legalistic. And crucially, it posed no clear and present danger to the court's ability to function. There it was again, the theme that pulsed through her entire defense. This wasn't rebellion. This was reverence. Not for individual justices, but for the Constitution they had all sworn to uphold. Justice Clarence Thomas, who rarely spoke during oral arguments, cleared his throat. You've cited a number of precedents, Miss Leavitt, but none of them deal with speech from an official representative of the executive branch. That's not a small distinction. Caroline nodded. Correct, Justice Thomas. And yet, that absence of limitation strengthens my argument. The Constitution does not carve out exceptions to the First Amendment based on one's job title. In Lane v. Franks, this court held that even public employees have strong protections when speaking on matters of public concern. She allowed the point to settle before continuing. And what could be more of a public concern than a Supreme Court ruling that directly affects national education policy? Several justices exchanged looks. This wasn't grandstanding, it was jurisprudence. Justice Barrett's tone had softened. Miss Leavitt, I must admit, this court did not expect such depth. Caroline smiled faintly. With respect, Your Honor, the stakes required nothing less. She continued, turning to Landmark Communications v. Virginia, a case that protected speech critical of judicial behavior. The court noted that injury to official reputation is not a sufficient reason for repressing speech that would otherwise be free. If that applies to judges under criminal investigation, surely it applies to constitutional critique of a policy decision. Justice Sonia Sotomayor glanced at her colleagues. It would seem your argument rests heavily on precedent. But precedent evolves. It bends with context. Indeed, Caroline agreed. But that bending should not become a weapon. Texas v. Johnson taught us that if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. The moment stretched. It was no longer Caroline on trial. It was the boundary between power and dissent. And she was defining it in real time. As Caroline Leavitt closed her leather portfolio, a hush fell over the Supreme Court chamber. What had started as a disciplinary summons had turned into a constitutional masterclass. Even the most seasoned justices could not deny the depth of her argument. Chief Justice Roberts nodded slightly, signaling a shift in tone. Justice Barrett leaned forward, her voice no longer sharp but thoughtful. Miss Leavitt, she said, you have raised serious constitutional questions that this court must weigh carefully. The gallery, packed with reporters and legal scholars, buzzed with a silent recognition. History was unfolding in real time. Leavitt's calm defiance had not only protected her career, it had challenged the very boundaries of executive speech and judicial authority. As the justices rose from the bench, the tension gave way to something unexpected: respect. Caroline Leavitt walked out of that chamber, not just as a press secretary, but as a constitutional voice that could not be ignored. Outside, the cameras waited. She paused, breathed deeply, and offered a quiet smile. Respect for the law, she said, means protecting the right to question it. And with that, she stepped into history. In the end, Caroline Leavitt didn't just defend herself, she made history. Her courage, precision, and unwavering belief in the Constitution reminded a nation that real strength lies not in silence, but in standing firm for what is right. If you were moved by this powerful story, don't forget to like, comment, and subscribe for more inspiring moments where truth triumphs over fear.